All right. Back on the record on State versus Ward. Mr. Ward and his attorneys are present. State Attorney's Office is present. I looked at the documents that you sent me. Thank you. You sent me. Thank you. In reference to Professor Davis's testimony. Mr. Jay, what is it about the documents that you think is objectionable?
Well, to label them all as the same thing is the first faulty logical premise. Some of these are bank records. Some of them might have stamps on them and signatures on them that might comport with self-authenticating documents. So we can't really lump them all into one category. But there's a lot of questions that I have, and one is, what opinion is Jeffrey Davis going to give that's actually an expert opinion about anything that requires these documents to be allowed under 9705 to be admitted or to be discussed. Like I said, he can come in and talk about tenancy by the entireties, business bankruptcy, and those sorts of things, but I don't know that he needs to do that with the documents. I don't know what the expert opinion is that he's going to give that necessitates him either relying upon those things or to allow this court under your discretion under 9705 to allow them to be discussed during the direct examination of him. I think if they want to start proving up the value of the tenancy by the entireties, or start proving up the value of Mrs. Ward's individual estate, or start proving up the individual value of Mr. Ward, they can do that, but they should have to do that under our evidence code and not be able to sneak it in basically through an expert witness that doesn't need to say those things to give his opinions about, hey, stuff in tenancy by the entireties is different than individually owned and whatnot.
So it's the amounts that you're objecting to? He did testify at length about they have this much money in this account and this is worth that.
But what's his opinion he's giving on that? Like, this is a well-planned estate or this was a crummy estate? I don't understand what his expert opinion that is beyond the ordinary understanding and experience of the jury, which would allow for an expert opinion to say those things. Again, if they want to prove up the values of their estates, then do it the old-fashioned way through the evidence code.
May I respond, Your Honor?
Well, I'm going to give you a chance to respond. I'm still not clear on what the state's objecting to. You're not objecting to him testifying to what tenancy by the entireties means?
Correct.
Correct? And I assume you're not objecting, I'm just basing this on what he said last time, okay? You're not objecting to him saying if Diane Ward passes away, then that property can be seized by a creditor. Is that correct? Or not correct?
I don't know. We'll see what Professor Davis says.
Okay. But you are objecting to him saying there's $1 million in a bank account?
Yes, I don't understand how that adds to his opinion unless he's given an opinion about the great planning or the lack of great planning or something like that.
Mr. Crown, he needs to see the Ward financial documents.
I don't think your mic is on. Or you don't have it pointed towards you have to point the microphone itself.
Up here?
Yes.
This better? Oh.
Much better, Ken, thank you.
He needs to see the Ward documents, because if he just came in here and testified that, you know, about the history of England and tenancy by the entireties, Mr. Jay would say, this is all irrelevant. So he needs to have a basis to give his opinion. And
what is his opinion?
But his opinion is that these properties, his opinion basically is what he said in the last proceeding, is that the Wards were careful about avoiding individual creditors, having individual creditors, and they were careful about planning their estates to have their accounts covered by tenancy by the entirety. And he needs to see the documents, and these are documents that are reasonably relied upon people and your professors who give opinion on the protections of tenancy by the entirety.
Why does he have to tell us what amounts are in bank accounts? What relevance does that have to anything?
Well, it's lack of motive for one. Why would Mr. Ward kill his wife if by doing so his accounts are now subject to, claims by these creditors. So
Well,
the protection.
how much is in the accounts is irrelevant to whether or not the accounts are protected.
Well, I mean, and let me understand, is Mr. J's objection to the amounts in the account based on hearsay?
Well, like for instance, in this trial with the DNA evidence, it's very nice to have experts come in and tell us what all that stuff means, but in order for the experts to be able to have an opinion about it, it has to be admitted into evidence. And so what I do is I call the CSI and they swab things and they do all that stuff. And so I think the expectation of the state is that somebody would properly admit these documents in order for somebody to have an opinion about them, because otherwise what he's doing is exactly what Professor Earhart would say is impermissible under 9704, which is regurgitating inadmissible evidence through an expert.
Did you follow that?
I did, Your Honor. Are you leaning that way now?
I'm just asking you.
Yes.
I'm listening.
Okay. Well, and another factor in this case, addressing the hearsay objection, is that the professor got these documents from Liz Green, who was the attorney in the bankruptcy litigation, represented them. They came from her files, and as data in her files. So we would argue that that's a business record exception to the hearsay rule, and so he should be able to testify not only that the documents are relevant to his theory of the protection of tenancy by the entirities, but also the amounts.
The business record exception only applies if they're actually in evidence. It's just a way of getting them into evidence. It's not a gate by which you can testify to documents that are not in evidence. So.
Well, we intend to call Liz Green tomorrow who could tie that together if that's an issue with the court.
The problem is,
Yeah.
so his expert opinion is what? Tell me again what his expert opinion is.
That it comes out to about $9,272,000. Those were amounts. They were in 4 accounts, 2 from GenSpring and 2 from SunTrust, and the death of Diane Ward subjected to that money in those accounts, subjected those to Mr. Ward's individual creditors. With her alive, the individual creditors could not get to those money in those accounts.
What is the relevance of the amount?
I think it goes to lack of motive, Your Honor.
If they're gonna tie it up with Ms. Green tomorrow, then I don't have a problem with it.
And
The state appears to be withdrawing their objection, but before, and I'm okay with that. Obviously, you need to lay a foundation with the professor, and you obviously are going to be required to tie this up with Ms. Green, or you're subject to having the testimony struck. But, so I don't need to rule it this time, because the state's withdrawing their objection subject to you tying it up with Ms. Green.
And let me clarify for the court. Ms. Green would tie it up as far as business record. We're not planning on introducing the documents into evidence today or tomorrow. You're just tying up the source of the documents to get a credible source.
Okay. Can we, based on what I saw last time, is there some reason that we have to hear the history of tenancy by the entirities?
Your Honor, I read it almost put me to sleep, and I know it's after lunch, so I'm going to be very brief, and we're not going to go into the English history.
If there's some, I couldn't figure out what that had to do with his testimony, but, it's your witness, so.
Well, it is after lunch, and it is bankruptcy law, which I'm still learning myself, so I think something brief would be a good point.
Just go slowly to make sure you instruct the witness that if he hears the word objection, he needs to wait until I rule before answering a question. But it appears that the issue's been resolved since you're going to tie it up with Ms. Green. At least Mr. J at this time has withdrawn his objection, so. All right, we ready to go?
We're ready.
Jury here, swearing back in. Stay recognized, presence of the jury.
Yes, Your Honor.
Defense.
Yes, Your Honor.
All right, have a seat, everyone. Hope you all enjoyed your lunch. Anybody try to talk to you about the case during lunch? You hear, read, or see anything? All right, thank you. Mr. Cromwell, you call your next witness.
Thank you, Your Honor. The defense calls Professor Jeffrey Davis.
All right, good afternoon, sir.
Good afternoon.
You've never actually had a client, correct?
That's correct.
And you don't have a Florida bar license, correct?
No, I'm an affiliate member of the bar, but I'm not licensed to practice law in Florida.
Okay.
I'm a member of the California bar, and I've never lived there since I got membership in the Florida bar. I've never lived there.
Well, rumor has it that's a much tougher bar. Okay. Now, so I guess part of what we're saying is that if Mr. Ward, for example, had made personal guarantees on some of the loans that were made to his corporations, then he could be subjected to, financial attack personally because he personally guaranteed those loans, correct?
Right, those are personal individual debts of his.
And because it's a personal debt that would not go into the tenancy by the entireties, correct?
Right, the creditors holding that personal debt could not get to entirety's property while the tenancy continues to exist.
Now, you said that if somebody were to attack both Mr. and Mrs. Ward financially, then that could go into the tenancy by the entirety, correct?
Right, joint creditors to whom they are both indebted.
And so you were aware that on September 1st of 2009, a complaint asking for damages in the amount of $7,542,371.94 had been filed by Bond Safeguard Insurance Company against both Mr. and Mrs. Ward, as well as the trusts for their daughters.
The truth is, I was aware of that when I previously testified, but that particular document didn't come to me this time.
Okay. But if somebody were to get a judgment against both Mr. and Mrs. Ward, that would attack the tenancy by the entireties, correct?
That's correct.
Now, in bankruptcy, instead of using the word deposition like we do in criminal court, you all have something called a 2004 examination, right?
That's right.
And there's really, like, in criminal and normal civil, questions during a deposition have to be reasonably calculated to lead to admissible information. But in a 2004 examination, it's much more like a fishing expedition. Isn't that fair?
Well, you can ask a broad range of questions. They all have to, in some way, have bearing on the financial condition of the person you're interrogating.
And so,
You can't ask personal questions.
so if a corporation is going into bankruptcy, there's a period of time, like 4 years in Florida, that the trustee of the bankruptcy can go back and look at disbursements and distributions out of that corporation, correct?
Anybody can.
And,
Any party in interest can do.
okay. And so during a 2004 examination, questions about every financial transaction a person has made in the last 4 years in relation to that corporation can be asked, right?
Yes.
And in fact, there's no rule against other witnesses that might be getting a 2004 examination in the future from sitting in on other people's 2004 examinations, right?
It's public record.
And so if Mrs. Ward were to be subjected to a 2004 examination before Mr. Ward, he would have the opportunity to sit in on it, correct?
They could certainly look at the transcript. I don't know whether he'd actually sit in on the deposition.
Okay. And vice versa. If Mr. Ward were to be examined first, Mrs. Ward would have the opportunity to see what he said.
Public record.
Okay.
You could see what he said.
And now, after these examinations, can the trustee of the bankruptcy then file adversary bankruptcy proceedings against people who they want to get assets back from that came out of the corporation to them?
Oh, yes.
So that's a potential consequence of these 2004 examinations is you learn about that sort of information to file those adversary bankruptcy proceedings, right?
The goal is to find assets
Okay.
that the bankruptcy estate can grab and distribute to creditors.
And so if Mrs. Ward were to become deceased, then the tenancy by the entireties was already 100% each of theirs, but her 100% interest disappears, right?
No, it goes to her estate.
Goes to her estate?
Yeah, your assets go to your estate.
Okay. Let's talk about that. So her last will and testament, who was her estate?
I haven't read her will.
I'm sorry?
I have not read her will.
Oh. Oh. And so if she didn't have a will, then it would pass through what lawyers call intestate succession.
Correct.
All right. So let's talk about another statute. Are you familiar with Florida Statute 732.802?
Not off the top of my head.
Are you able to read that, or would you like me to?
Kill or not entitled, well, you just rolled past the part I was reading.
So, can you read that?
Kill or not entitled to receive.
Don't read it out loud.
Oh, sure. I can, wait, yeah. Okay, I read it.
All right. Are you familiar
read
with the
the title.
statute?
Well, I've read the title.
Have you read? Are you familiar with the body of it?
No. I'm not familiar with the body. You want me to read it?
Okay. Well, let me ask you a couple questions. In Florida, if somebody is found to have unlawfully killed their spouse, do they have any right to inherit from that person that they killed?
Based on the title of this statute, I would guess no.
And if they were to be found to have unlawfully killed their spouse, their tenancy by the entireties turns into a tenancy in common.
Right.
And tell the ladies and gentlemen what tenancy in common means.
Tenancy in common just means that you each own half, an unspecified, undivided half.
And so if you and I own a condo together somewhere, without any repercussions, I can sell my interest in that condo to anybody, and he'll be your new roommate.
That's correct.
All right. And so, are you also familiar with Georgia statute 53-1-5?
Nope.
All right, so you don't know whether or not Georgia law also provides for these same principles of law as Florida, correct?
That's correct.
All right, so let's step back one. So in order to get at the tenancy by the entireties before Mrs. Ward is deceased, they would have to get a judgment, creditors would have to get a judgment against both Mr. and Mrs. Ward, correct?
Yeah, in order to get entirety's property, you have to have a joint, you can only get at it if you're a joint creditor.
And if Mr. Ward was found to have unlawfully killed Mrs. Ward, we would still be in the exact same situation because they would be tenants in common, so somebody would have to get a judgment against her estate as well as Mr. Ward to get at the full 100% of that property.
Yeah, in order to get both halves, in order to get both shares, you'd have to get a judgment against both owners.
And if he was actually in her will or in her line of intestate succession, Florida statute that I showed you provides that it passes as if he had predeceased her, so he doesn't get any of that. Would that be accurate?
I can't give you a legal opinion based on this chat we are having.
Okay. But you're the one that's called here to explain tenancy by the entireties in bankruptcy, correct?
Yeah, that's correct.
All right, thank you. No other questions?
Redirect.
No, Your Honor.
May this witness be excused?
Yes, Your Honor.
Yes, Your Honor.
Thank you, sir. You're free to go.
Mm-hmm.
Call your next witness.
Your Honor, defense call Sarah Ward.
May I inquire?
Thank you, Your Honor. Sarah, could you state your full name?
Sarah Caitlin Rupp.
Okay, and I called you Ward. Did you just get married?
Yes.
Okay. Is Ward your maiden name?
Yes.
Okay. How are you related to Bob Ward?
That's my dad.
Okay. Can you describe your relationship with your dad?
I love my dad. My relationship with him is really, really good. We're really close friends, and I speak to him all day, every day.
Has that always been the case?
Yes.
Was that the case before your mom passed away?
Yes, it was.
Did that change after your mom passed away?
No.
How about your relationship with your mom? Tell us what that was like.
My relationship with my mom was excellent. We were best friends. A lot of my friends would call us sisters because we were so close.
You spent a lot of time with her?
I did.
Did you travel with her?
Frequently, yes.
For what reason?
She would come to horse shows with me. I love horses, and she was always there with me.
When you traveled with your mom, would you share a hotel room or would you have separate hotel rooms?
Sometimes we'd share a hotel room. Sometimes we'd get separate. It depended on how much she was snoring that night.
When that occurred, when you would have the same hotel room, did you share a bathroom?
We did.
Okay. So, did you have any familiarity with how your mom was with her medication?
Yes.
How was that?
Kind of flippant. I mean, there would be pill bottles on the counter. I'd see them in her purse. It would just be an all day kind of thing I'd know she'd have pills around and out.
Do you know why she was taking these medications?
I know she was anxious. At the time, that's all I really knew.
And just so we can understand, how old are you during the time, or on the day your mom died? How old were you?
I had just turned 19.
Okay. Did you spend time both in the Atlanta house and the Orlando house?
I did.
Okay. Describe how much time you spent at each, generally.
I grew up in Atlanta with my family in the Atlanta house, and then when my dad and the company moved to Florida, I would spend time equal parts in Orlando and Atlanta.
Are you familiar with the master bedroom in the Orlando home?
Yes.
How?
We'd spend movie nights when I was there in that room. My mom, my dad, and I.
Okay. Your Honor, permission to show the witness Defense Exhibit 1?
Granted.
Okay. Sir, does this accurately depict the master bedroom at the Orlando home?
Yes.
Okay. Now, did your mom and dad have sides of the bed?
Oh, yeah. Every place we ever lived, they had their own sides.
Was it always the same side at each place?
It was always the same.
Okay. Which side? Your Honor, may the witness
She
step
may.
down? Sarah, could you just step down, please? Which side of the bed was your mom's side and which side was your dad's side?
This was always my dad's side of the bed, and this was always my mom's side.
Okay, thank you. Were you aware of a gun being kept in the Orlando home?
Yes, I was.
Were there more than one?
Yes,
Okay. Were you aware of a gun being kept in the master bedroom?
I was.
How?
One of the movie nights we had, I had seen him open his side of the bed because that's where the remotes were in the night table. And that's where it was, and that's where it had been in every house we've been. It was always in that same spot.
Well, let me back you up for a second. You said that's where it was in every house you've been in? What do you mean by that?
In the Atlanta house and in the house in Orlando.
So in each of these houses, your dad had a habit of keeping a gun at the nightstand of the bedroom?
Yeah, he always kept one for safety.
Okay. Was your mom aware that your dad kept the gun in the nightstand in the bedroom?
Yes, he was.
How do you know that?
She had been there when I had seen it that one night when we were watching movies in Orlando, and she had seen it in Atlanta. We all knew that that's where it was kept.
Do you know how the gun was kept in the nightstand?
It was always holstered.
Okay, do you know what color the holster was?
Black.
Was that the same in the Atlanta home?
Yes.
And do you have experience handling firearms?
I do.
Does your sister Mallory have experience handling firearms?
She does.
Does your dad have experience handling firearms?
He does.
Okay. Does your mom have experience handling firearms?
No.
Who taught you how to handle firearms?
My dad.
Who taught Mallory?
My dad.
During the time you were living in the Orlando home, did you have an opportunity to see your parents interact?
I did, yeah.
And were there ever fights?
They argued, they'd bicker about like the dogs would bark. But a lot of times if my mom had been drinking, she would pick fights with my dad. I'd see her like kind of try to start a fight.
Sustained.
When she would pick fights with your dad, how did your dad react?
Oh, he'd walk away. He'd, she'd been drinking and he would just excuse himself. He'd go to his bedroom and go to bed.
Are you familiar with your mom's drinking?
Yes.
How?
I spent so much time with my mom at the horse shows, on the road, at home. I would always see her with a bottle of wine or two. It was not unusual.
Did there come a time when your mom stopped drinking red wine?
Yes, for a time.
Okay, when was that?
Like late spring, early summer 2009.
Okay, and why?
Sustained.
Okay. Did there come a time when your mom started again drinking red wine?
Yes,
When was that?
like about a week before I had lost my mom.
Your Honor, may I have one moment?
Yes.
Thank you. Sarah, do you love your mom?
Love my mom and my dad.
Took my next question. Thank you. No more questions.
Cross.
Hello.
Hi.
Your mom was right-handed, correct?
She was.
And you were aware of some of the financial issues that were going on in 2009?
2009, yes.
Talks about not spending as much?
Yes, sir.
And your mom perhaps blamed your father for the financial issues?
Yes, she did.
Were you aware of your mom being treated for any mental illnesses?
At the time, mental illnesses, no.
All right. And when you said that she took a lot of medication, she also had a thyroid issue, is that right?
She did.
And she had pain issue because of her lower back. She would periodically get epidurals and stuff, right?
I did not know that.
Okay.
Literally the first
She
time I've heard.
talked to you a lot about her life?
Yeah, anxiety.
How about her shoulder? She ever talked to you about the rotator cuff?
Yes.
How about her neck issues?
First time I'm hearing of that.
Okay. And is it fair to say that your mom's CrossFit routine really consisted of just walking the dogs?
Yes.
Okay.
She's not the CrossFitter my sister likes to claim she is.
All right. So she's not like hulkingly strong or anything like that?
Oh.
Okay. Now, with your mom's drinking, did you have any concerns that she drank to excess?
I was 19 at the time. I thought my parents knew what was best. I knew it was typical for her to have at least a bottle of wine.
Okay. And typical is like almost every day?
It was unusual for her to have less than a bottle and a half of wine.
Okay. And your mom wasn't a very coordinated person, was she?
I've inherited that, unfortunately, so yes.
Right.
I mean, no, she was not.
A little clumsy?
Yes.
Okay. And she was forgetful?
Yes.
So if anything, she would forget to take her medicine.
She would forget it and be like, oh, I forgot it, and take more.
Okay. And you talked to her that night on September 21st, 2009, right?
I did. I talked to her several times that day.
And as we've heard, she was Italian. So she was
Very.
very, very, very concerned about you maybe having the flu, right?
It was swine flu, and I did think I had it.
And she was going to fly up there with minestrone soup, right?
If only.
Okay, but she was talking about flying up there.
She was going to come see me, yes, before we were supposed to go to a horse show.
And that conversation was about 5, 6 p.m.?
Yeah, that sounds right.
Okay. And she sounded normal?
She did, yeah.
Couldn't tell that she had been drinking when you spoke to her on the phone at that point?
Couldn't tell, but she said she was drinking.
Okay. And I know through past conversation, you're aware that there was something called the Irrevocable Sarah Ward Trust, right?
Now, yes.
But you didn't know anything about it back when you were a teenager when it got created.
I knew there were trusts.
Okay.
Really didn't know what that meant.
You weren't going to board meetings for Land Resource LLC as a part owner, right?
No.
Okay. No other questions?
Redirect.
Sarah, you were asked a number of questions about your mom's medications for various ailments. With regard to what she was taking for her anxiety and depression, did she have a name for those?
Yeah, she'd say, I need my happy pills. That was not unusual to hear from her.
And did she have a period of time when she would take them more than other times?
Yes.
What would that be?
A lot of times if she was feeling really anxious, if there was drama at the horse shows, which if you're a teenage girl, there's always drama. And yeah, she'd ask me to get her happy pills out of her bag. That was a typical thing.
Sarah, thank you.
May this witness be excused?
Yes, Your Honor.
Yes, Your Honor.
Thank you, you're free to go.
Your Honor, may we approach?
Yes. All right, ladies and gentlemen, we've had some witness issues that aren't going to put us behind schedule at all. In fact, the defense's case will be concluded tomorrow, probably by noon, maybe. It might extend a little bit, depends on the witnesses. We're having a little bit of a scheduling issue. We are going to finish on time, but we don't have any other witnesses to testify today. So what I'm going to do is send you all home early. We're going to stay and get everything ready to go so that we can move smoothly through this. We will finish, we may actually finish early, but we're going to finish on time. So you get an afternoon to yourselves. You know the usual rules. Don't enjoy your afternoon, which you appear to be ready to do. No looking at anything on TV. Don't look up anything on the internet. Don't talk to anybody about the case. Have a good evening. We'll see you tomorrow morning in the jury room at 8:45 in here at 9 a.m. Thank you. Depending on how tomorrow goes, you all need to be ready to do closings tomorrow afternoon. I really can't. If you end in the morning, I can't justify not going. So let's do the jury charge conference. Have you all been able to talk about the jury instructions since yesterday? You got to put the mic on.
If it pleases the court, Mr. Braven, who's been admitted pro hac vice in this case, is going to handle the jury instructions.
Okay, come on up. Come join us.
I need my bag, yeah. No, I need my computer. Good afternoon, Your Honor.
Good afternoon.
Thank you.
Fine. Mr. J, did you make any changes from yesterday evening?
I had a couple other things to do based on the turn of events that keeps on turning. So no, I've not inserted the deadly force self-defense instruction yet. The other things I believe I typed as we were going along. And the state's going to have a couple of written requests for jury instructions as well. The one that I've already drafted and had ready ahead of time was the explanation of what Florida calls the Slayer statute that we were just discussing with the good professor. I think also I'm going to have to add in the fact that in Florida, one of the 6 cornerstones, if a building could have 6 corners, of tenancy by the entireties is survivorship. So, you know, when he testified that when Mrs. Ward passed, that her 100% interest of the tenancy by entireties would go to her estate instead of to the surviving spouse, I'm going to have to type up some jury instructions on that, I think.
Yeah, that was incorrect statement of Florida law. In Florida law, tenancy by the entireties, when one person dies, the other person owns 100%. It does not go to their estate.
I understand that my grandfather was a Florida resident until he passed away last year. So.
There you go. So,
With respect to the jury instruction, does it make sense for Mr. J and us to talk for a few minutes at least? Because the answer to the question, have we spoken, was no, correct?
I would be more than happy to have you all talk for a few minutes while I take care of a few issues that have popped up, and then let me know when you're ready to do a charge conference. That
Thank
work
you.
for everybody? All right, I'm going to turn off. You all ready, or you need more time to talk?
I think at this point, we're just doing our homework, primarily me, going through the justifiable deadly force instruction. Mr. Lavin?
Raven.
Raven.
All right, sorry.
Okay.
He's going to email me what he proposed for that particular instruction, and so I think we're all on the same page. Like I said, I just got to do that. I got to craft survivorship by tenancy in the entirety.
You just need to make that simple. The court now instructs you that the law in Florida is that the survivor of a tenancy by the entirety inherits the entire amount immediately, or something to that effect. Just keep it simple.
I would never be brief. I'm kidding.
I will be, unless you want to see me go like this.
No, I'm being sarcastic
Yeah.
since I'm brief.
I know. Just get it down to something simple. The court now instructs you, this is the law on tenants by the entireties in the state of Florida. So justifiable homicide, we don't have any issue about which one we're using, correct? It's the law that was in effect at the time. I looked this up. It's the law that was in effect at the time of the shooting, so.
Well, so far I've been working with the modern day one, but
Okay.
I can go back to the old one.
As long as you all are satisfied with the justifiable homicide instruction. But yesterday you were saying that you wanted the one that was given in the original trial, which is the one that
That would
was
require me finding a hard copy of it somewhere in our 8 boxes. I think it's there somewhere, but
of the jury instruction?
the original one, yes.
It's in the court file.
Yeah, it's on the docket.
It's on the website. I have it.
All right, that'll be easier.
I just hit the print key. All right. Defense, are you objecting to the use of the original justifiable use?
Well, to be honest, we had been working with the new one, and I was sending my draft of that. I want to review the other one if I can. We're close on everything. I think we've got very limited.
There's not a significant difference between the two as it applies to this case.
Okay.
Because this doesn't really come in, the stand your ground issues do not come into play in this case.
In fact, they're strange in the. They're strange applied to this case in the current instruction.
Right. That's why I'm saying,
All right,
read
so-
the old one, because the one that was used in the original trial is pretty clean.
Okay.
Seems to apply to the facts of the case. We've already agreed on all the other second-degree murder. You fixed the manslaughter instruction, commas all where they're supposed to be.
Commas, no intent to kill.
Thank you. Any other lessers being requested by either side?
No, ma'am.
State, defense?
No, Your Honor.
Because all we have is manslaughter, all right?
Yes, sir.
Like I said, do 2 sets. You know that I do 10 sets for the jurors. Do 2 sets, one with the defendant testifying, one without the defendant testifying. Anything else that is coming up?
No, I just think we need time to do it, and I
Well,
would
that's
prefer to
why
have, I would prefer to have 3 monitors in front of me if I can have time to do it elsewhere.
Oh, we're not going to do it in here.
Okay.
I'm just going on the record right now, which is what I need to do. Make sure there's nothing you need me for, and then I'm going to recess court so you all can go get your jury instructions done, and Mr. Gillen can start working on his closing. I know.
Your Honor.
All good lawyers have already started on their closings. Yeah? Yes, sir.
We may be able to work it out. It may be agreeable, but there may be a slight issue as to the third part of the excusable homicide instruction. I haven't determined if we have any basis in light of what Mr. J told me in regard to my suggestion, if we have any basis to ask for what I've suggested.
You're talking about paragraph 3, when the killing is committed by accident and misfortune?
Yes, I am, Your Honor.
Okay. You're going to request something different than the standard? Or you're thinking about it?
I'm either going, well, yes, I was going to request something different because there was a dangerous weapon used, but the defense theory has been that it wasn't introduced into the sudden combat by Mr. Ward. And so I think the instruction certainly wouldn't cover the situation as given. It wouldn't be applicable as given because we all concede that there was a dangerous weapon involved. And so we'll either agree to strike that or we'd prefer a modification of it. Would you like to hear my proposed modification?
I thought you guys were going to talk about
Well, we
it.
can't talk about it. I was telling you, I was just previewing that that's the only issue that may involve judicial intervention.
I don't like his modification, so.
I already knew that, Mr. J, but thank you for articulating it. Go ahead, you can tell me what your proposed modification is.
Well, my proposed modification would have paragraph 3 reading, when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not introduced into the combat by the defendant and the killing is not done in a cruel and unusual manner.
My initial reaction to that is not a positive one. However, I'm certainly willing to listen to argument on it. There are a variety of reasons why my initial reaction is not a positive one. I'm going to give you guys time to work on it and see, but
Yeah,
there's
It
a
may not be
series
an
of
issue, Your Honor.
cases about this and what excusable homicide is.
And I saw the Supreme Court law when they were moving away from the phrase applying to all three, absolutely, and I just wanted to know if there were any that dealt with the specific motive. I understand the statute
Right.
itself is ambiguous or could be
And
read
the
as
Supreme
ambiguous.
Court case is,
Yes, Your Honor.
I'm very reluctant to go along with your request. However, if you have some case law that supports your position, I'll certainly
Your
entertain
Honor.
it. Sure. Anything else?
just that, I think as written, that might swing the pendulum too far to the state side since it contradicts the self-defense law. But I think his language might swing the pendulum a little too far to the defendant's side in misstating the law when you get into the bulk of the self-defense law.
These are the standards of Supreme Court instructions. I get what you're telling me. And if you all can craft,
What I was saying is I would agree to striking through it and just letting the self-defense instruction explain the difference between all those things. But I think the notion that, who introduced the weapon into the situation isn't exactly the law either.
it's not. That's, yeah. So,
Well, I think I appreciate you be willing to strike it. I think the argument would be it just doesn't apply to the facts of this case. I think both parties agreed there was the state's exhibit is a dangerous weapon according to the definition.
I'm fine with striking it. I have it stricken already for the delete button, so.
And I want to go back to where we were, which was don't like it, but would give me a chance to raise something if we find it. and I expect you-
your choice, if I still don't like it after I've given you a chance, is you want it stricken,
Yes, Your Honor.
and the defense wants it, and the state wants it. Now I'm doing it, and the state wants it stricken.
The state will acquiesce to it being stricken. If that makes a difference
Not to me.
semantically.
It doesn't make a bit of difference to me, but
And
fine.
it doesn't make a big difference. If it stayed in as it is, I think it would just be inapplicable. So it doesn't matter that much either way. We can work it out or make you work it out, Your Honor.
Try and work it out amongst yourselves. If you cannot, then I'll intervene. But anything else?
No, ma'am.
Court's in recess. Have a good afternoon working on jury instructions, folks. I'll see you tomorrow morning.